Hey everybody, welcome back to Tim Travels. I'm Terry, your host, coming to you from near I-81 in Virginia. I'm not going to say exactly where. Why? Because I'm selfish. And it just so happens that I'm at a place that doesn't have many truck parking spots. And believe it or not, and I'm serious about this, while I would share this information with people that, I know personally, I don't really want to go, global with it because, people are always looking to me for advice. So I'm not going to share where I am. But I am going to share something that may pass as advice, although I would say it's not advice. It's just how Terry might handle something where you're in a given situation. So I got a call. Well, actually, I got a text from a friend, somebody I know and I talk to all the time. And they said, hey, I got a friend that's got an issue with Prime. And the fact that it's Prime is immaterial to this discussion, but I'm just sharing the facts with you. So they said, hey, they got a problem with Prime. Can they call you? And I'm like, yeah, sure. So they give the person my number, and this person calls me and they tell me that they had, and they're not at Prime anymore, but they had a lease with Prime, and they had some situation where their truck, basically the transmission crapped the bed, and or they were broke down and it needed a tow. Now I might be getting this a little bit backwards, but again, this is kind of filler. It's not really germane to this whole discussion, but I give you the backstory a little bit. So in any event, they get towed, and it turns out their transmission is jacked up. And I don't know if it's from the tow or if it was jacked up to begin with. So Prime is like, hey, this is a warranty issue. This truck needs to go to Freightliner. Freightliner's like, no, it's not a warranty issue. The front half of the transmission, the front end of the transmission, like where it bolts to the engine, is effed up. And so they're going back and forth, and they're like, this is because the tow truck driver didn't disconnect the drive shaft correctly, or words to that effect. So then, Prime's like, well, it's not covered under the warranty that we have, which I don't know if that amounts to a hill of beans. But in any event, this goes on so long that they give this person a loaner truck, but they're losing their shirt, right? Because now they're not really running that hard. They're making payments on a truck that they're not able to use, and the bill comes out to be, several tens of thousands of dollars for these repairs. So this person is like, I'm sick of being grossly in the hole. And their fleet manager's like, oh, just hang in there, just hang. And they're like, nah, I'm going to turn the truck in. And then, the fleet manager's like, oh, I could have taken care of you, blah, 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 if you finished your lease. But keep in mind, fleet managers get a bonus if you finish a lease. Now, you get a bonus too, right? If you're close to the end, you probably want to hang. So anyway, fast forward a little bit, this person leaves Prime and they go get a job at another trucking company. They're a good driver. They get hired right away at another company, and they're very happy there. And they're working as a company driver, but they make that company pays well, and they talk to me about their company. But anyway, they get an invoice from Prime for $16,000, and that was, after they netted out some other stuff, I'm sure the performance bond and some other stuff, right? And prepaid insurance premiums or whatever. So they get this bill for 16, 18 grand. And again, the numbers don't really matter that much to this because we're not in a court of law. So they said, what do I do? What can I do here? Like, is Prime going to come after me for this money? And so here's where we get into the whole idea of owing. And this is going to be true if you owe anybody anything, right? But in particular, people seem to end up owing trucking companies. And let me just bracket this for 1 second, because I read just today, about a truck driving school, and this happens fairly frequently. And I apologize for going off on a tangent here, but I just thought of it about owing money, right? A lot of times people come to trucking companies and they get their CDL at a trucking company, like I did, and like a lot of people do, and certainly a gazillion people have gotten it at Prime and all these other mega carriers. But a lot of people also pay sometimes a lot of money to go to a truck driving school. And the people who've gone to a truck driving school have always said, well, hey, I paid for it, and maybe they got GI Bill, maybe the state gave them help, they, whatever the situation is that they felt was good. And they felt like it gave them independence, right? They weren't beholden to anybody. They didn't have a year contract or the threat of paying back, But this trucking school up in Buffalo just shut its doors. Well, these trucking schools all want the money up front by and large. Not all of them, but most of them want the money up front. And this isn't the first trucking school to shut down. And a lot of these places, because I go by them, I see them, and a lot of them are sketchy as hell, in my opinion, just to look at them, right? I look at like the pad that I was on at night, or the pad that I worked on at Prime with people, and a lot of these places are like a little gravel lot with some cones set up, and they're churning out people, but they're also charging people like $8,000, $9,000, $12,000 up front. And a lot of these places, they're not regulated, they're not reputable, right? Like, they close down, people haven't finished their course of study, and these guys are just everybody's money's gone, right? So anyway, and so truck driving training is often why people end up owing trucking companies money. But in this case, like I was saying, it was some huge repair bill. Now, you may recall that Prime said that I owed them money, but I basically pushed back and said, no, the company that I worked for, that I was a W-2 employee of, owes you money. Go talk to them. And what happened with this person that I talked to, I said, hey, did you have an LLC? Because companies like Prime, they love to have you set up an LLC, because they love to hide behind that independent contractor facade or legality when it benefits them. But when it doesn't benefit them, like when they're trying to come after me personally for money, then they're all butthurt about the fact that there's this corporate entity and it's limited liability. That means the people that hold equity in it have limited liability, limited to the contributions they made. In other words, if you start an LLC, you put $10,000 in a bank account, you run the business for a couple of years, it goes out of business, and there's liabilities that the company has accrued. Well, the limit of your liability is the $10,000 that you put in, meaning you might not get that back. That's your liability. That's the whole reason behind corporations and companies and partnerships and trusts and all that. It's to limit individual liability. So I said to this person, hey, was it set up? Is it on the straight and narrow, right? Was like your LLC's name on the contract with Success Leasing? Was it on the contract with Prime? And they said, not exactly sure, although I did have an LLC. So then they said, what if they come after me personally? And I said, well, first of all, here's what has to happen. And this is where this gets good, right? So Prime has an arbitration clause in its, mandatory arbitration clause in its contracts. However, even if they in order to get money out of somebody, so you could say, oh, you owe us $16,000, and the person could be like, I ain't paying it, right? And here's the first pro tip. If somebody says you owe us $16,000, the first thing out of your mouth should be this: I want affirmation of the debt, or confirmation of the debt. Not affirmation, but confirmation. In other words, I deny that I owe you anything. Prove to me otherwise. Now, that triggers them having, I think under federal law, 30 days on a debt. And here's the interesting thing: if they try to come after somebody individually, then it's going to be a consumer issue, right? Because if there was an LLC, then they just got to sue the LLC, right? Unless there's a personal guarantor, and I could cover that maybe in a different video. But anyway, I said, supposing for a moment any trucking company wants to come after you, they might have a bill collector try to call you, a collection agency. And you could just be like, yeah, I don't know that, but if you want to send me proof, then I'll look at it. But I don't owe it. And never qualify what you're saying in your denials. Never say, I don't think I owe it, or I don't believe I owe it. Just say, I don't owe it. Prove otherwise, and make them prove it. But even if they send you something that has your signature all over it, it's notarized, you gave them your social, all that mess, you could still deny it, right? Deny the claim, right? So then let's say that they file an arbitration claim against you. Again, deny the claim. Say, there's no basis for this. I don't have a contract with them. And the term that I used with them was, I didn't have contractual privity with them. And what contractual privity means is that we have a contract, like they and me, Terry, not the LLC I work for, but me personally. They have a contract. I'm like, we don't have privity. We don't have contractual privity. Please stop blowing your horn. I don't know why that car has an alarm. It is like a really old Honda Accord that's burgundy mostly, but then has some primer colored body parts on it. I would actually want somebody to steal that. Anyway, and even if it is, just insure it against theft. Get you a new car if somebody steals it. So I was like, hey, I don't have contractual privity with you guys. You go call somebody else, but it's not me. I don't have a contract with you. So that's the first thing, right? And I told this person, I said, even if Prime went to binding arbitration, mandatory arbitration, they went to binding arbitration and got some award, then they still have to do what is called domesticate a judgment. And after an arbitration award, which is not a judgment, they would have to go into a court of competent jurisdiction. And what competent jurisdiction means is that court has the authority pursuant to the rules of civil procedure in that state, because they're not going to go in federal court for this, because it doesn't reach it's not a high enough threshold. I think I'd have to look at the rules now, but I think any amount in controversy for federal court has to be north of $80,000. So they're not going to, no trucking company's going to do that unless you, like, I don't know, burn their building down or something. But they're going to have to get a judgment from a court of competent jurisdiction. So I would assume that Prime would try to get a judgment from a court in Missouri. But if the person doesn't live in Missouri, then in order to try to collect on that judgment, they're going to have to get the judgment, what is called domesticated, in the state that the person lives in. And in my example, this person lives, I believe, out in Colorado. And or at least they did when they worked at Prime. I don't know if they're still living in Colorado. But so then they would have to domesticate a judgment in a court of competent jurisdiction in Colorado. Okay, but now there's a judgment and you're like, well, man, that's bad. That's going to hurt my credit. And the answer to that is, yeah, it is going to hurt your credit, because one of the options I discussed with this person was bankruptcy, because they were like, well, I got some other debts. What if I just declare bankruptcy? What'll happen? And I said, well, Prime ain't getting a dime, and you can get rid of your credit card debt, medical debt, whatever. I used to do bankruptcy work for people before the 2005 changes to the bankruptcy code. And I explained all the ramifications of bankruptcy to this person. I said, you know, it's kind of a silver bullet, but it's one you only get to fire very infrequently. You know, but they're like, well, then my credit will be ruined. And I said, you know, it turns out, because this happened to clients of mine way back when, and this is when you could file over and over and over. Those 2005 changes kind of stopped that serial bankruptcy filing, people that were serial filers. But I would have clients that once we did what is called the 341 meeting, which is Section 341 of the Bankruptcy Code. It's called Meeting of Creditors. Once we got past that point and it was pretty clear that there was going to be a discharge in the bankruptcy, they would start getting credit card offers and all sorts of offers right away. And the other thing that's also you should keep in mind about a bankruptcy, if that's like your nuclear option, silver bullet thing, is in most circuits. So now we're talking federal circuits, because bankruptcy is federal law. In most circuits, and probably in all, if you're making payments on something like a car, something that's a secured debt as opposed to credit cards. So a secured debt, you can keep that secured collateral as long as those payments. So let's say you were like, hey, Prime says pick a company, right? They say I owe them, Hirschbach. They say I owe them $20,000. You could declare bankruptcy, totally wipe out that debt, assuming it was valid, right? Why declare bankruptcy to wipe out an invalid debt? But you could wipe that out, and let's say you had you have a 22 Silverado pickup that you're making payments on. As long as the payments are current, the lender's going to let you keep that, because they don't want your collateral back, because it's probably not worth what you owe on it. And if they take it back, they get zip from you. They get the collateral, but that's it. And then somebody else is going to loan you money for a car, right? Because it's secured. And then as to mortgages, mortgages are protected under the bankruptcy code, like let's say you're current on your mortgage or whatever, or your apartment rent even. You're not going to get evicted. You're not going to get foreclosed on, because there's two things. One is just the bankruptcy code itself, but there's also homestead laws that protect debtors. That's how O.J. Simpson avoided paying the Goldmans and the Browns for committing those murders that he got found liable in the civil court for, because he used the homestead exemption that they have down in Florida. So Florida is, it's got a lot of things, but one of the things it has is it's a hideout for people that committed double murder to avoid civil penalties. And by the way, Florida's not the only state that's like that. I'm just kind of dogging Florida, but it wouldn't have been the case if he had all his property in California, though. So getting back to what to do about this. So let's say you don't want to declare bankruptcy, or you can't declare bankruptcy. And by the way, bankruptcy is individual. So if your spouse, you wouldn't have to include your spouse on a bankruptcy, although it might impact their credit. But the idea that you're not going to have access to credit if you declare bankruptcy is kind of a misnomer. You're going to have a jacked up credit rating, which is going to affect the interest rates that you pay. And it may impact some people being willing to give you credit. But, you're not going to buy a house in the year after a bankruptcy, probably, with your name on the note. But as far as just surviving day to day, consumer credit, having a car loan, you'll be able to have that. But let's say you don't, you're not going to do that nuclear option, and you're just like, screw them, I'm not paying them anything. Well, here's where it gets interesting, right? First of all, it costs money to sue people, and lawyers aren't cheap, even if they're doing, like I represented a lot of banks, and the firms I worked at, and even my own firm, we represented mortgage lenders, mortgage holders, and that work per case is not super expensive for the creditor, but that's because there's a huge volume of cases. But unless I miss my guess, a lot of these trucking companies are not bringing, like hundreds of lawsuits a month. Like I used to represent Citibank. I worked at a firm but I was in court for Citibank all the time, like 10 court appearances a week, right? 1 in the morning, 1 in the afternoon. That's all I did at one firm, is just litigate for Citibank. And I was, like I said, my firm probably took in, 500 new cases a month, because we handled 3 different states, Maryland, DC, and Virginia. And I would say at least 500 new cases a month, because we would have these, what we called signing parties, where all the complaints, all the documents would be prepared, and a couple of the attorneys would go into a conference room, and all the admin staff would be in there with boxes full of complaints, and we'd just be reviewing them, sign them, review them, sign them. It was like an assembly line almost. They call them mills. So if you do get sued, right? Well, one of the things you can do is, again, you just deny the claim. And then if you're really a go-getter, you look up all the rules and you say, okay, well, I got sued, so I have the right as the defendant to what is called propound discovery. And discovery is typically 3 different things. And how much of it you are allowed to do is going to be dependent on the rules of civil procedure in that particular jurisdiction, but also oftentimes the size of the case. But one of them is interrogatories, right? That's written questions that somebody has to answer in writing under oath. The second thing is request for production of documents. Now, here's the interesting thing. You can request production of documents in interrogatories, and interrogatories are often limited by number per the rules. And the third thing are depositions. Now, depositions are not cheap to conduct, because you have to have a court reporter. You're going to have a location. You're going to have to notice people. But you really could do it. Like if honestly, if Prime sued me and I was feeling it, I would depose Robert. I'd make Robert Lowe come to where I was, and I'd notice a deposition. I'd move, I'd try to move it jurisdictions. And there are a million little tricks that lawyers know to confound plaintiffs. There are also a million tricks that plaintiffs know to confound defendants and get judgments for their clients, right? Like, that's how the game is played. But even if somebody does get a judgment against you, then they have to collect. And that kind of starts a whole procedure over again. And that's called post-judgment, like, discovery. And then that's when you can be forced to come to court. Because in a civil case, you don't have to come to court. If you're not subpoenaed, just because you're named as a defendant doesn't mean you have to show up. Now, if you don't show up, they're probably going to get a judgment against you by default. But you might be like, I'm not showing up to any court in Missouri. Screw them. And so if they do get a judgment and they domesticate it where you are, then they're going to want to conduct what is called post-judgment discovery, and that is to try to get assets. Now, yeah, part of the process, the collection process, is garnishing bank accounts, garnishing wages, and getting statements of assets under oath. And there are pretty severe penalties in some states. Maryland was one of them, where if you don't show up for this court-ordered discovery, because now there's a judgment, you can get some pretty severe penalties, including what is called a body attachment, which is like a civil arrest warrant, and you would actually have to post bond for that. But I don't want to get too far out in the weeds on that. But here's how you protect yourself. So no bank account with a judgment against a single individual can be garnished if that individual has no individual bank account, checking, savings, whatever it is, right? In other words, if your wife or even one of your children is on a bank account, that cannot be garnished for your debts because it's a joint account. Same thing with like any property that's owned jointly cannot be, it cannot be levied or liened or anything for a judgment against an individual. Now, they could find out where you work, and if you're a W-2 employee, not if you're a contractor, but if you're a W-2 employee, they could garnish your wages if they have an order of the court. The way around that is, change jobs or be a contractor. The easiest way around that is to just be an independent contractor, because then they have to find out who your employer is to garnish your wages. And if your employer is you, because now, let's say they did find out, now there are rules, state rules in the state you're in about how much can be garnished in order to satisfy the judgment. And it may seem like I'm telling you, oh, this is how you avoid all debts, blah, blah, blah. I'm not here to tell you that you should just blow off all your creditors. And if you do, then just go declare bankruptcy, but know you're only going to be able to do it once, and once per a long time, 7 to 10 years, probably. It's not, like I said, it's the silver bullet. It's the nuclear option. But if if you're in a situation where some big company that was probably taking advantage of you anyway, and like somebody gets their CDL, and the company's like, oh, you owe us $6,000 if you leave before a year. And then they're like, oh, we found a scratch on your truck, we're terminating you, and you've only been there 3 months. And that happens all the time, right? It happens all the time. And then they're like, oh yeah, you got fired, so you owe us, $8,000. Go tell them to pound sand. Be like, you want $8,000? You better go ask somebody else, or give it, the old college try, because I'm not paying you. And these are some things that you should know if you get in that situation. And, you don't want a judgment. So you always push back on it. Be like, and honestly, if I was a CDL graduate, I'd be like, hey, you guys terminated me wrongfully. You could throw all sorts of stuff at them. And by the way, if they sue you, you can then put all that stuff in what is called a counterclaim. But you have to follow the rules, and you have to meet the deadlines. But anyway, I don't know I hope this was helpful. A lot of people reach out to me about bull crap stuff that these trucking companies are pulling, trying to recover this, trying to recover that. And I'm just like, no, don't pay them. Don't pay them. They're going to, they can write it off, but don't pay them. You don't owe them anything. I mean, just because they say that you do doesn't mean you do. And when I used to defend credit card cases, that was the first thing I learned, is just because somebody says it doesn't mean it's true. That's what courts are for, to balance everything. And if you deny, because that's what the big boys do, everybody, when there's some disaster, right? What do companies do? First thing they do is they come out and they deny. So it's what's good for the goose is good for the gander. So hit me up in the comments if you got questions. If there are more specific things, I could talk about those too. So anyway, be safe. Talk to you soon.